brothers and sisters, and friends, and I see some enemies. In fact, I think we'd be fooling ourselves if we had an audience this large and didn't realize that there were some enemies present.
Well, listen, Gary, if we can go back to one of the original questions I had about like the discovery and filing it, as well as the motion to dismiss, would it be?
Don't forget a Brady request.
Yeah, the Brady. It's discovery / Brady request. That's kind of what it is.
Okay.
I submitted that. Let's say I got the ticket, right, and then let's say 2 days later I submitted that with the court. All right. Now, that's the proper? I'm going to say procedure. I know probably you're going to disagree with me, but I guess the way I'm supposed to handle it. I shouldn't wait for the arraignment because a lot of tickets don't even have a date for court date. Or it's not mandatory rather. So they want you to call them for you to show up, and then they give you another date, and they kind of proceed that way. But I'm in the right by doing that, by filling out the paperwork and submitting it within the first 10 days of getting the ticket.
You got the ticket? Is there any court case to file into yet?
Well, once the ticket is submitted to the court, I would assume. Okay,
so they didn't submit the ticket to a court and open up a folder of sorts, right? Is that what you mean?
It's just what they're expecting me to pay, and that's it.
Well, yeah, but they did put it into the court, so there's a folder, an accusation.
Correct. It's in the computer. I guess they don't use folders anymore. It's like a computer now. There's a file or open on the computer.
You've been accused in a court setting. Let's put it that way.
Correct.
And so your response was they failed to state a case, right? And so you filed for a motion to dismiss for
causation,
lack of jurisdiction. At least if they had any reason to believe they had jurisdiction, they wholly failed to provide that evidence. Okay.
So now my main question. So would I be that's okay to do it, or should I wait for, I got a date to go to court saying, hey, listen, I want an arraignment.
Why do you want to wait? I mean, I don't understand the concept of wanting to wait. Why, what do you think the benefit of waiting is?
No, I don't know. I'm asking, is it, I don't know what their procedure is as far as are they opening up a court or not.
I don't either. Okay, I'm trying to separate two issues.
Yeah.
The person to ask about procedural issues is the clerk. Logic issues we can discuss. Ethics issues we can easily discuss. I don't see any logical or ethical issue with filing what you did, right? But who knows? Maybe that clerk said you can only file paperwork on Thursday at 3:23 p.m. and other than that, it's not appropriate. I don't know what the hell she's got as rule.
I'm telling you, you'd be surprised, man. These clerks have no idea what they're talking about, or no idea what it is. Like, what is this? We don't know what it is. We can't accept this.
I wouldn't be at all surprised.
No, I was saying that, because I sent my girlfriend to submit it, and they're like, oh, what is this? We don't know what this is. Oh, you don't do this here. And then I had to physically go there and do it, and they're like, I'm like, oh, no, you have to go to arraignment first, and then you can have a court. I'm like, no. I could challenge jurisdiction any time, I told her. And I'm challenging it right now, and you guys got to take this by law. Well, yeah,
that's
whatever.
An assertion, and that's a horrible assertion at that. Maybe next time you might want to think about asking. It's like, I'm attempting to file this document. Are you telling me that you have no mechanism by which to file this document and that you're refusing to file this document? Just to be clear, are you telling me that I don't have the right to file this document right now? And that you will, in fact, stop me from doing so? So the point that I'm trying to make with that exchange is I'm trying to get that clerk to confess something rather than her trying to kind of deflect me and say, oh, how about you do this crap instead? And I'm saying, okay, just to be clear, you're going to stop me from doing what I want. Is that what you're saying? And then she'd probably say, oh, no, I was just suggesting a better way to do it. And it's like getting them to confess the wrongdoing that they're doing rather than having the excuse of saying, well, all I was doing was trying to say it'd be better for him to do it, blah, blah, blah. No. If I get a yes or no to, are you intending to stop me from doing this? Yes or no? Because then I would go to the next level up and say, your clerk stopped me from filing this motion. Why don't I have the right to file motions in a case that's been opened against me? How is that justice? How is that related to due process if I don't have equal access to filing motions?
Because they were saying stuff like, "Oh, you should, you got to wait for you go to arraignment first before you can file these kind of paperwork." So
bullshit. Bullshit. Yeah. Are they saying that if I filed the case against the judge, that he would be forced to come to a hearing before he could file a motion to dismiss? You bet your ass he'd have a motion to dismiss in and granted before the day was up.
And that's kind of where I got upset. You know, I lost my cool. I'm like, wait, what are you guys talking about? You guys are supposed to take this paperwork. You know, it's your duty as a clerk. Yeah.
You got to learn how to ask a damaging question and embarrass them into doing. Because ultimately, yeah, it's their job. I get it. But you got to get them to confess that they're not doing their job. Otherwise, it's just you saying they're not doing their job. If you can get them to say, I'm not going to do my job, it's so much more effective. It's like, okay, just for the record, you aren't going to do your job, you know, with a better phrasing. That at 3 o'clock, I came here to file this stuff here, and you actively refused to take it. By the way, let's also note that on blah, blah, blah date, you had no problem accepting the prosecutor's motion and pleadings, right?
One question I had is here, at least here on here, I don't know if it's around where you guys are or not, but a lot of the times the prosecutor's in another office out of the courtroom, you know, trying to make plea deal with everybody, you know, during arraignment. So there's, like I'd say about 90% of the time when you're up in front of the judge, the prosecutor's not even there.
Good.
So, you know, and my question kind of comes down to, so what would my options be if the prosecutor's there? Because the judge one time said to me, the prosecutor's not here, I can't help you.
Why would your options change? Because the prosecutor didn't give a damn about doing his job.
But that the judge is allowing it, though. That's the thing. The judge is like, well, the prosecutor's not here, so we're going to set up for a trial date.
Again, the same thing that I just got done saying about the clerk goes to the judge, too. All right, Judge, I am pointing out that there was some clarification needed about the cause and nature of these proceedings. You're telling me to piss off because the prosecutors didn't bother to show up here at the arraignment to prosecute his case. I don't care why. I don't care if he's in the bathroom wanking off. He didn't care to be here to prosecute his case. And you're telling me because he isn't here to prosecute his case that I should do without the information that he would normally be obliged to give? I have some objections to that. On what grounds, what grounds are you giving him that kind of latitude? Now, I try to form that in the phrase of a yes/no question. But
so your objection would be objection to the fact that the prosecutor's not here to state his case, or
I'm quite okay with the prosecutor not being there. I want the prosecutor to fail to state his case and go home. My objection is not that the prosecutor's not stating his case. Okay, just to be clear, if the prosecutor fails to state his case, I'm happy. If the judge excuses that failure and wants me to continue on as if the prosecutor had stated a case, then my beef is with the judge for a short bit. And then later with the prosecutor for failing to state a case and failing to object to that judge, allowing such a horrible thing to be done. Because when the judge doesn't dismiss or fix that mistake, he's actually screwing up the prosecution. It shouldn't be doing him a favor. It is, we know, because they tend to steamroll those favors. But I don't have any objection. I don't want the prosecutor to state a case. I want to have asked sensible and honest questions, but I don't really want him to answer them. If he doesn't answer them, we should go home. It shows the dishonesty. It shows all of that, right? If you file a case against the IRS, do you think they want you to state a case? They want you to fail to state a case. Instant dismissal, right?
Because they I've had the judge, man, yell at me. I had him intimidate me, so give me a time. One time, I didn't know. I was kind of naive, and I was like, that little door you pass by, and I asked him a simple question like, hey, am I entering any contracts by passing this door? And he's just like, what? No, you're not under any contracts. Oh, God, don't tell me you're one of those sovereign citizen guys. And then he got really short with me. I'm like, no, I'm not a sovereign citizen. I'm just, here to ask questions of the natures and causes of this proceedings or these hearings.
Why
and he's just like,
why did that question anger him so? Well, the question I'd have is, okay, that was a simple clarifying question. Why did you get so offended and angry by it? Honest, sincere questions that are relevant and not unanswered there's no good justification for the judge to stop them from being asked. And if he's trying to stop them from being asked, then suddenly we put on our Columbo hat. We put on that Columbo hat and we start investigating, and we always are investigating why things are going the way they're going. And if that judge is showing a bias like that, we start investigating why he's showing that bias. And if he's showing bias, then it becomes a question of, you've demonstrated several issues of bias. Why aren't you recusing yourself if you're this biased? Technically, if the prosecutor sees a bias in the judge, he should want that judge off the case so it doesn't risk his prosecution. He doesn't want his case to get overturned because the judge showed, had some bias, right? I mean, he should care about his job. We know that they have a little system going in which the prosecutor knows that he's going to get his back washed, and he's not going to object to a judge's bias because he knows on the whole that's great for him. You might lose some extra ones on appeal, but you get far more income and far more convictions, Anyone who notices a show of bias should be objecting, including us. Now, again, a show of bias should be mentioned. A show of bias should be a motion to strike and recuse and all that kind of stuff, maybe. It really is a judgment call as to what you think. I mean, if you're still in the arraignment phase, who gives a shit about what judge? To a certain extent, if he's got some biases he's shown, you can still keep getting information. If he's starting to make decisions and push you through to, pretend that he made a plea for you and all that kind of crap, then it might be time to, to motion him to recuse himself. Basically, you're saying, here's all the things that you've done that showed a bias. Maybe you should recuse yourself so that there's no questions. And if he fails to do so, everywhere has different procedures, but you might motion whoever the hell gets motioned to disqualify him. Disqualify him because he is biased, he's biased as made evident by all these actions that he's done.
Yeah, it's funny because one time I asked him, oh, it's in the Sixth Amendment I'm allowed to do, and he's like, oh, what does the Sixth Amendment say? He asked me. I'm like, I couldn't say it verbatim, I'm just.
You made an assertion and he nailed you on it. You made an assertion and he nailed you on it.
Yeah.
Because if you quoted it, he would have said, all right, why do you think that that's relevant here? Boom, what are you going to say? Because I want it to be, damn it. I was like, yeah. I'm not convinced by that, The same thing that we're doing to judges, prosecutors can do to you. If you make an assertion, man, lights on you. They pull these games. Then they start nailing you on your assertion, which is what we're trying to do to them on their assertion. You violated this applicable law. Oh, really? How do you know it was applicable? Of course, they leave out the word applicable. They leave that as implied, right? But of course, they're implying that it's applicable. They're not saying you violated this inapplicable law. That's not what they're saying. They're saying you violated this law and it applies. Yes, Socratic approach. There should always be a question on the table that embarrasses them and demonstrates the flaws in what they're trying to assert. Just like he did to you. You said, oh, the Sixth Amendment says blah, blah, blah. And he says, oh, yeah? What does it say? Boom, he nailed you. He said, prove it. Right?
Yeah, I think comedy expects of me. Everybody's laughing and it's all right.
Right. I mean, that's part of it. They use all these things, all these tactics.